All right, good morning. Welcome to our CPC committee. Is our first committee of the day, the Committee on Professional Conduct. It is March 22nd, 2018. I'm going to go ahead and call the meeting to order. But if we can just go ahead and start with a roll call. I'm going to have to start with Mr. Famala at the end.
Present.
Can you say your name?
George Camerlett.
Thank you. Alicia Burhow.
Dan Jacobson.
Jose Campos.
Okay, well, thank you very much. I am filling in for Deidre Robinson today, so hopefully she will be able to be here for the next meeting, but we'll go ahead and start with CPC item 2, 10A2. So can I call up Ms. Sanchez to be, oh, I'm sorry, what did I do? Oh, I have to do minutes, sorry about that. So, see, this is what happens when I've been out of power for such a long time. All right, so, okay, we'll go ahead and do approval of the minutes. So do I have a motion to approve?
I move approval of the minutes.
And I second that.
Okay. Is there any questions or discussion? Any questions or comments from the public? Okay. Can we go ahead and do a roll call?
Okay, Alicia Burhow.
Yes.
Jose Campos.
Yes.
George Famila.
Yes.
And Dan Jacobson.
Yes.
Okay, thank you for that. Okay, now we will call Ms. Sanchez up to talk about our first item of the day.
Thank you. Okay, good morning. Oh, take out the table.
Oh, good. All good.
Okay. So I am here to present CPC item 2, which is discussion and possible action to initiate a rulemaking to amend Title 16 California Code of Regulations, Section 87 and 88, continuing education rules.
Great.
So, to begin, the purpose of this agenda item is to provide an opportunity for the California Board of Accountancy to consider taking action to approve the proposed language for CBA regulations section 87 and 88. This will institute 4 additional technical subject areas and increase the allowable continuing education or CE credit for specified activities. Attachment 1 is the model rules for continuing professional education, Article 3, which I refer to as the rules. And attachments 2 and 3 are the proposed amendments to CBA regulations identified by underline and strikeout. At its January 2018 meeting, the CBA was presented with the final version of the rules. After discussion, the CBA directed staff to draft regulatory language to amend CBA regulations sections 87A2 to add 4 new technical subject areas to the existing technical subject areas, and section 88H to increase the total hours of CE credit allowed during the renewal period from 25% to 50% for specified activities. First, let's start with section 87, basic requirements. The proposed language is identified with an underline on page 1 of your attachment 2, under 87A2. The 4 additional technical subject areas are business law, economics, management, services, and statistics. Moving on to secondly, section 88 is programs which qualify. The proposed language is identified near the bottom of page 2 of attachment 2 under 88H.
Thank you.
At this time, I would like to highlight an error on this page of the attachment. You may have noticed under 88H that 25 has been stricken. However, the 50 has not been underlined to identify this as the new information that was added. This will be amended as a non-substantive change, and if approved by the CBA, will be corrected as it moves through the rulemaking process. This change will allow up to 50% of CE credit during a renewal period for the specified activities which are listed in subsection G. These are summarized as writing published books and articles, writing instructional materials for CE programs, writing questions for the CPA exam, and performing a technical review of instructional materials. I would now like to turn it over to the chair, and if the CBA supports the proposed regulatory language for CBA regulations section 87 and 88, staff recommend that CBA make a motion to approve the proposed regulatory text in Title 16 CCR sections 87 and 88, and direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
Okay. I'd like to open it up for the members to ask any questions. Then I will take that liberty. So, well, I had a quick question regarding attachment 2 on, if you could just help me with this, regarding the sexual harassment issue. You know, programs in the following, so at the bottom of attachment 2, programs in the following subject areas are not acceptable toward meeting this requirement: sexual harassment, workplace harassment, or workplace violence.
That falls more under our ethics requirement.
Okay.
Which I do address a little bit more on the next paper.
Okay.
However, the ethics requirement, when that was originally brought to the CBA for a decision, a task force was created. And at that time, when the task force was created, they determined that those areas did not meet the overriding determination, whether it qualifies as acceptable continuing education relating to the competence of a CPA in public practice. So that was decided back when the ethics requirement was put in 10 years ago.
Okay. Thank you for that.
You're welcome.
All right. That was my only question. Any other questions from the members?
I move approval of the recommendation as it was read and is listed in the cover memo.
Okay.
I second.
All right, I have a first by Mr. Campos and a second by Mr. Familat. Any other questions or discussions from the members?
I was wondering if we could cut that into two, because I had planned to vote, as I had in the past, against the 87 proposal and vote for the 88 proposal.
I think because we have a motion already, do we have to take that first? Unless you want to offer a friendly amendment.
I offer to amend that the motion be cut into two, and so that the 87 motion is
Separate from the
separate
88?
from the 88 motion.
Do you want to take that? Or
Why
do you
don't I
want,
withdraw my motion, and why don't you make a motion?
why don't you make the motion? All right.
All right.
Then we'll have, then I'm going to have you do it.
I move to approve the motion regarding 88H.
Okay, but not, so you don't, so do you want to do 88H and then
That's all
87?
I move.
Okay. So I have a motion to approve the proposed language for CBA regulations section 88H and direct staff to initiate the rulemaking process. Is that the motion?
Well, it's regarding the percentages.
I just want to make sure I'm getting the right motion, so,
Okay.
all right. Is that what you're
My
asking?
understanding is that 88H dealt with the
88H.
percentages.
Yes, that is correct. So
That's-
make the motion, yes, so CBA motion for 88H to approve the regulatory text and do the remaining items as identified in the cover.
Okay. So we
Okay,
have
I
a motion.
second that.
All right, a second by Mr. Campos. Any other questions or comments from the members? Any comments or questions from the public? Okay, all in favor, say, I'm sorry, you'll do a roll call.
Okay, Dan Jacobson,
Yes.
George Familat,
Yes.
Jose Campos,
Yes?
and Alicia Burhow.
Yes. Okay, with that, the motion passes unanimously. Okay, is there any other motions that the members would
I
like
would
to make?
move to approve the recommendation as to section 87 as listed in the memo as it relates to section 87.
I second that.
All right, so I have a first by Mr. Campos and a second by Mr. Familat. Any other questions or discussion from the members? Any questions or comments from the public? Okay, with that, we'll call for the vote.
George Familat,
Yes.
Dan Jacobson,
No.
Jose Campos.
Yes?
And Alicia Burhow.
Yes. Okay, with that, the motion passes. Okay, thank you very much for that. Moving on to the next item, 10A3.
Okay, I'm here to present CPC item 3. This is also in regards to the model rules. However, this is an informational paper in regards to comparing the model rules to the California Board of Accountancy Ethics CE requirements. Okay, your attachment 1 is a copy of the rules. This agenda item is being provided for information purposes. No specific action is required on this item unless the CBA decides to revise any CBA regulations. Just for some quick background, active CPAs complete 80 hours of CE in a 2-year period immediately preceding their license expiration. As part of the 80-hour requirement, a licensee must complete a minimum of 40 hours, or 50%, but can complete all 80 in technical subject areas. Conversely, a licensee may claim no more than 40 hours in non-technical subject areas. We commonly refer to this as the 50-50 requirement. Included in the 80 hours, CBA regulations also require a licensee to complete 4 hours of ethics education, which we consider as technical CE. At its January 2018 meeting, the CBA was presented with the final version of the rules and was asked if members wanted to implement or modify any of the rules in the CBA regulations. After a robust discussion, members requested that staff bring back more information regarding why the rules defined ethics into 2 subject areas: regulatory ethics and behavioral ethics, which is considered technical and non-technical. In response to our request for more information, NASBA provided the fields of study that qualify for continuing professional education, and that is your attachment 3. This document provides general subject matter that qualifies as meeting the regulatory ethics and behavioral ethics requirement. These are listed as bullets on page 3 of your agenda item. The CBA comparison is at the bottom of page 3. Upon review, staff determined that the CBA regulations encompass most of the rules accepted, technical and non-technical subjects referenced, with the exception of sexual harassment, workplace harassment, and workplace violence. Staff also determined that the CBA regulations have a thorough definition of ethics that do align with the rules and include varying subject matter, which allows licensees several options to complete the CBA's 4-hour ethics requirement. At this time, it is staff's recommendation that no changes to the ethics continuing education requirements be made, and that concludes my presentation. I would now like to turn it over to the chair for discussion.
All right. Thank you. So do any of the members have any questions or discussion on this? Okay, no motions? All right, we're good to go. Thank you very much.
Thank you.
Okay, so we're going to go ahead and move on to item 10A4, and Mr. Franzella. Is he available? Yes, he is.
Good morning.
Good morning.
So I'm here to provide an overview of CPC item 4, which is information regarding the regulatory cannabis responsibilities related to legalized cannabis. So with the passage of Proposition 64 in 2016, California voters passed laws related to legalizing cannabis for recreational use, and Prop 64 allows adults to grow, possess, and use cannabis for non-medical purposes, and it made it legal beginning January 1st of this year to sell and distribute cannabis through a regulated business. This item is being provided to the CBA to offer a high-level overview of information regarding the regulation of legalized cannabis. And California law placed primary responsibility on 3 state agencies to regulate the cannabis industry: the Bureau of Cannabis Control, who this board heard from, I want to say July of last year, from the Bureau Chief, Lori Ajax, at a pretty high level, but it was a relatively lengthy presentation she offered, the Department of Health, and the Department of Food and Agriculture. And on page 2 of your materials, I've highlighted a quick snapshot of what areas of regulatory responsibilities those agencies are responsible for. And on the bottom of page 2, and then it continues onto the top of page 3, I've highlighted several recent ongoing public policy matters that impact the overall regulation of cannabis. These have included the U.S. Attorney General Sessions' decision to rescind the Cole Memorandum, disallowance of cannabis-related funds to enter the banking industry, developing standards to assess cannabis-related impairment, and enforcing laws to minimize the underground cannabis economy. So as states have passed various cannabis-related laws decriminalizing the use of cannabis, boards of accountancy have seen a kind of an increase or an uptick in requests from licensees regarding guidance and requests for positions on professional services. And in the attachment to the materials, I've included a document that NASBA has compiled as various state agencies issue position statements. They update this doc, and I want to say the most recent one is of January 2018. And it has 12 states who have issued some type of position statement related to providing professional services to cannabis-related clients. And boards have issued statements that address it in basically two different ways. One is that providing services to cannabis clients is not a matter that would warrant board action, or that servicing clients in the cannabis industry is not a violation of the good moral character laws within that state. These types of position statements are in essence comfort statements, and the CBA doesn't issue comfort statements. And what's more, these statements are legal opinions, are in essence legal opinions, which the California Office of Attorney General is the sole agency responsible or authorized to provide such opinions. So when staff are contacted about offering services to cannabis-related clients, we let the individuals know that the CBA doesn't have a position and that they need to seek legal counsel to assess the risk factors before undertaking such an engagement or engaging with such a client. Staff are exploring developing a web page to provide links to various governmental agencies. I believe the state actually even has a cannabis.org web page. We can direct them to the Bureau of Cannabis Control. The State Treasurer's Office has a considerable amount of information related to work on the banking industry. The new Office of Tax and Fee Administration has information related to the sales and use tax, and FTB as well. So at this time, staff recommend that given the infancy and ever-fluctuating regulatory scheme for the oversight of cannabis industry, and as many state and federal public policy questions remain, that the CBA directs staff to monitor the progress associated with the regulation of cannabis and keep the CBA abreast of any significant issues impacting either the CBA itself, the accounting profession, or the CBA's consumer protection mandate. And at this time, I'm happy to turn it back over to the chair, and I'll try to answer any questions you have.
Oh, I'm sure there's many now. I'd like to go ahead and turn it over to the members and see if there's any questions. So, well, and then I'll go ahead and do it real quick. So are you seeing an uptick, or do you see maybe in the future that you're going to see more of our licensees who are going to be coming to us and asking us for guidance?
It happens regularly.
It happens regularly, so,
Yeah.
so I'm assuming staff's going to continue monitoring those requests and looking at those questions that they have as this moves forward? So,
Yeah.
all right, never mind. So- Okay, any other questions from the members?
Well, it seems like that was part of the recommendation. Is there a need for staff to have a motion or a action from the board on that topic? It seems like that would just be a normal
Go for it.
process.
We don't need a motion, and we would, as those questions come in, if there's anything that's relevant, we would ourselves reach out to the Cannabis Bureau and relay that information. So we're in regular contact there as well as with the department on those issues that come up.
Yeah. And is there any intent, I mean, so I see these various statements that these states have. Are we aware of any intent by the AG's office or somewhere to provide something like this on that website that kind of, because this isn't just a Board of Accountancy issue, right? It probably cuts across various boards. Is there any intention on that front?
No. I would, the AG's office, and I think I quickly highlighted in it, they only respond when a request is made by a state official to do so. So they don't just unilaterally take legal positions unless they're, or issue a legal opinion unless there's a request to do so. But at this time, I'm not aware of anything. They're holding a number of informational hearings and policy hearings with the AG being included because so many policy matters, public policy matters are being thrown in flux, especially with the federal government and the AG sessions rescindance of the Cole memorandum.
So how do we advise licensees, right? So people are asking us, we're saying we don't issue these. Yet the state's got some law on the books, right, that allows for this, but that not only does it seem to be different than federal law, but it might be different than specific provisions in our regulations that people might see. How would we direct licensees? Take it up with the AG's office, take it up with some other agency? I mean, what's the feedback to licensees?
Presently, we just tell them they need to seek legal counsel and assess the risk factors, because there's more than just us saying whether or not it would be legal to take on that client. There's a number of other risk factors they would need to do. And while cannabis presents a unique situation, we don't offer a position on anybody's clients. We've never said you can take client A but not client B. We don't have any. So this would be a very unique situation if all of a sudden we came out and said servicing a particular client is not in and of itself a violation of our law.
Yeah, but this is
It's unique.
quite unique. And
I agree.
This is a banking industry, sort of normal cash flow issues for these licensees, federal law to which they have to comply. I mean, there's just a variety of levels that makes this different than just client acceptance. I'm just trying to understand what avenues, the licensee population has to not land in harm's way on something like this, other than getting an attorney to evaluate things.
And honestly, I think that is their best direction, is to seek an attorney. I think the board can, and we've, as I mentioned in the paper, we are exploring providing more information, so where they can go to gather stuff like on cannabis.org, the Secretary of Trade's website, so they can collect information they need. But I think it's been been our position in the past that we can't offer that legal opinion, and they need to seek that legal guidance from outside counsel.
Is there any avenue that we can suggest to the AG's office or someone else or the cannabis department saying, hey, look, we're getting these questions, it's your area, you need to address this? I mean, it's broader than this board, it's a lot of boards, but they're obviously being out there on a component, they've got tax revenue that they're gaining from this. This is kind of an open issue that's they need to address. And if there's a avenue that we can basically say, here's a problem, add it to your list, but you should address this because this is going to continue to create other problems that you may not have attended. You guys want to do this, figure it out, and give some guidance.
So I think right now, as they're still in the early stages of implementation in California, the Cannabis Bureau is working very closely with the Attorney General's office. They're working closely with the administration, and so I think that's probably going to progress naturally as they move forward. When we have issues raised that are specific to the accounting profession, we do communicate those over to the Cannabis Bureau and the administration, letting them know areas that we see they need to focus on. So I think at some point that will occur. I just think right now, until such time at a federal level, there's resolution, and the administration in California is working to try with federal government to try to reach some resolution on this issue. So I think that will occur naturally. Whether the board would want in and of itself to request that, it may be a bit early to do that, in my opinion.
Well, I think you kind of answered the question along Mr. Femelot's view that I had. So we get these questions, we're doing something with those questions. We're not just saying, sorry, we can't help you. We're
Go somewhere else.
passing the topics along to administration, AG's off, whoever the appropriate party is.
Not only the questions that are raised to us, but just as we're monitoring it, as they're drafting regulations, we've been involved in that process just from a review standpoint, and areas that we see could be problematic specific to the accounting profession, we actually have at a staff level shared that with the administration. So we are, I wouldn't say involved in the process, but we're certainly monitoring it, and they have reached out to us on a couple occasions for input and guidance. So I think that is happening naturally.
So maybe I will make a motion after all.
Goody.
To not only to adopt the recommendation that you've listed in the cover memo to this material on monitoring and briefing the board on developments, but also to continue your process of ensuring that concerns raised by licensees get passed along to the appropriate parties in the state for consideration.
Okay, we have a motion by Mr. Campos. Is there a second?
Second.
Okay, second by Mr. Fomalette. Any questions or discussion?
Yeah, I have a question. Is staff concerned that it's going to be kind of stuck with with a requirement of doing something with a phone call rather than sometimes saying you need to get a lawyer. Because if that is the case, I don't want staff to be stuck with that.
I want to think that's the
I-
spirit
yeah.
of the motion here. The
Yeah.
spirit of the motion is continue doing the things you're doing and the feedback you're providing licensees, but the topics that are raised by these licensees, that at least that is categorized and submitted to agencies that, would have that under their purview. I don't think it changes our communication back to the licensee.
And this is also just about making sure that our licensees understand that we're looking out for them.
And would this be with staff having wide discretion on the categorization?
Absolutely.
Good.
Any other questions or discussion? Any comments or questions from the public? Okay, with that, we'll call for the vote.
Okay, Alicia Burhouse.
Yes.
Jose Campos.
Yes.
George Familet.
Yes.
And Dan Jacobson.
Yes.
Okay. With that, the motion passes. Thank you very much. Okay, we are going to go ahead and move on to public comment. The California Board of Accountancy welcomes public comment during this section of the agenda. However, board members are prohibited by law from engaging in dialogue or taking a vote on any matter brought up during public comment. If you would like the CBA to discuss a general topic, you can ask the board to consider placing the issue on a future meeting agenda, provided it is not related to a specific case involving one of its licensees. If you have a pending application, investigation, or disciplinary charges, the CBA is prohibited by law from discussing any details or receiving evidence or information during the public comment portion of the meeting. In order to allow the CBA sufficient time to conduct its scheduled business, public comment will be limited to 5 minutes per speaker. Please make your comments focused and relevant to the duties of the CBA. Okay, we have one public comment.
Yeah, my case is closed, so I'm here to talk about,
If you could please say your name.
Joanne Hinkle.
Okay.
I'm here to talk about high-functioning autism. You'll get one of these packets, high-functioning autism, and as I was interviewing CPAs for my presentation, they mentioned the MCI, adults, mild cognitive impairment, which develops 5 years before an adult starts getting dementia or Alzheimer's. So that's who my talk concerns. My name is Joanne Hinkle. For 31 years, I helped the Labor Department with high school worker labor law complaints. I'm trained as a quality reviewer for work experience education. I own usworkworld.com that provides lessons to special ed high school students. My education is listed on this packet you will receive. As we all sit here, AI and AI bots are marching forth. CBA duties include granting CPA licenses, monitoring CPA licenses, accepting out-of-state CPA licenses or out-of-state CPAs for licensing, and processing consumer complaints about CPA activities. In a few short years, artificial intelligence and AI robots will perform maybe even better than humans. The granting of CPA license, monitoring of CPA license, the accepting of out-of-state California CPAs for licensing, leaving this committee with the only task AI can't do, jobs that require creativity, curiosity, and empathy, or the thinking jobs that deal with people, such as the processing of consumer complaints about CPA activities, the only job AI will allow CBA humans to do in the future. I filed the CPA complaint against 2 CPAs for my mentally challenged nephew in May of 2015. My case was closed with no violation of Accountancy Act in November 2017, 2.5 years later. I was so confused about what was happening during the complaint process that my sister and I filed a complaint with the EEO about CBA. The EEO ruled that CBA treated my nephew no different than any other complaint. It was then that I was horrified. It made sense. Accountants, people of trees rather than the forest, had sat through the 60s, 70s, 80s, 90s, and clear to 2018, not seeing that the forest has changed. Accountants sat with the trees as the U.S. government lowered street curbs for wheelchairs. installed blinking lights in fire alarms, and installed chirpers in traffic signals. Accountants sat with the trees as employers installed raised counters for wheelchair assembly workers and picture registers for workers who cannot do math. Accountants sat with the trees as the state of California passed laws to accommodate even illegals. Every force in existence is providing protections and accommodations for the disabled, except CBA, who is keeping its eye on the trees. Well, the time has come for CBA to face 2018 and the forest. From my perspective, the only job that AI will allow you to do in the future desperately needs your attention. Is the CBA complaint process, my opinion, incompetent, lazy, or corrupt? I cannot decide. What I can decide is the CBA complaint process is unorganized, unfair, and a fly-by-the-seat-of-thy-pants operation. I did not receive one correct document mailed to me during the CBA complaint process, and it goes downhill from there. How can CPAs be so inept? Is this by neglect, accident, or planned? I don't know. My area of concern is estates and trust. My nephew is a mentally challenged young adult. He takes care of himself barely. I'm not talking about the severe mentally ill. He was a beneficiary in a $30 million estate who was thrown under the bus by trustees, innovative CPA, and tree-hugging CBA. And my area of concern is the burden that is placed on fixed income taxpayers like me and California State by trust CPAs who cooperate with trustees to make items like income instruments and trust disappear so that wealthy families can enjoy the money after moving the mentally challenged beneficiaries onto public assistance. The CPA told my nephew, "Your dad's trust was not funded. You didn't want to pay 45% tax on the dollar, did you?" Well, I sure did. And the trustee told my nephew, "We plan to put your dad on public assistance." Our country has problems. Lois Lerner held on to the belief that conservatives are bad and ended up doing bad herself. James Comey and the FBI held on to their belief
Ms.
that
Hinkle, your 5 minutes has
Okay.
expired.
I will continue.
Okay. All right. Are there any other items at this moment? Any agenda items for the next meeting? Okay, with that, we will go ahead and adjourn. Thank you.